I'm going to just call us to order briefly. You're all very welcome to the second edition of the Keough-Naughton Institute's Women in Leadership Forum, and the first probably in many years, if not ever, where Keough-Naughton has been able to do something with our partners in the law school, which we're terribly pleased to do. So my task, I'm Colin Barr, I'm the director of the Keough-Naughton Institute and professor of modern Irish history in the Keough School of Global Affairs, and I have the easy task today of introducing Father Bob Dowd, which I will do in a moment. He has the more challenging task of introducing Dean Marcus Cole and Lady Chief Justice Siobhan Keegan, and he will tell you about them. I want to begin very briefly with a small number of acknowledgements. First to Dean Cole himself for agreeing to join us and to conduct this conversation. I think one of the real strengths of Notre Dame is the ability to work across disciplines, across units, and we're very, very pleased to be working with our colleagues in the law school. Thanks also to Dean Mary Gallagher of the Keough School of Global Affairs, who's joining us today, and also to Eamon McConville, your principal private secretary, who, as Grania and Ariel in my office said, we felt he should really be coming on this trip because he's been spending so much time with us, almost as a member of our staff, to make all this possible. He is not here, but we did want to thank him, and please convey our thanks to him for the really excellent collaboration we've had. Now, Father Robert Dowd, CSC, is the University of Notre Dame's 18th president. As president, he has devoted himself to furthering the university's mission as the preeminent global Catholic research university. Father Dowd is a professor of political science at the university, having been part of that department since 2004. Ordained a priest in 1994, Father Dowd has ministered to students on campus for many years as priest in residence in Dillon, St. Edward's, and Kavanagh Halls, and also is a great friend of Ireland and Keough-Naughton. And I just missed you by a few days, I think, at Kylemore this summer. Father Bob, thank you so much.
Colin. Thank you very much. Well, thank you. Thank you very much, Colin, and welcome everybody on this beautiful day. It's a great to be together. And I want to welcome everyone on behalf, first of all, of course, of the university, but I want to thank you on behalf of the Keough-Naughton Institute for Irish Studies and also on behalf of the law school. It's great to be together this afternoon. This event tonight is part of the Women in Leadership series run by the Keough-Naughton Institute and its Klingon Center for the Study of Modern Ireland. Inaugurated in 2024, the series brings women leaders in the fields of law, politics, policymaking, civic society, business, and beyond to Notre Dame to share their knowledge and expertise with our campus community. This series is one of many initiatives that the Keough-Naughton Institute has created to advance policy-focused research, programming, and partnership across Ireland and the world. Another initiative of particular note is the Institute's Errands Project, or Analyzing and Researching Ireland North and South. In collaboration with the Royal Irish Academy, the Institute founded Errands in 2020 to support independent, nonpartisan research on the island's constitutional, political, and indeed legal future. And so it is a true privilege to have the Right Honorable Dame Siobhan Keegan, Lady Chief Justice of Northern Ireland, here this evening to share her insights as an experienced judge and barrister, and as the first woman to serve as the head of the judiciary of Northern Ireland. Dame Keegan was sworn in as Lady Chief Justice of Northern Ireland on September the 2nd, 2021. In 2023, Queen's University Belfast conferred on her an honorary degree in Doctor of Laws distinction in public service. Dame Keegan has been an inspiring figure in Northern Ireland whose career has been defined by breaking barriers and a deep commitment to public service. So thank you. Thank you, Dame Keegan, for making the long trip to visit us here at Notre Dame. It was an honor to have the chance to chat with you before this event. We're so grateful for your presence here. Let's give Dame Keegan a round of applause. It's also my great pleasure to welcome Dean Marcus Cole, a great friend and colleague of mine, a leading scholar of the law and economics of commerce and finance. Dean Cole was a member of the faculty at Stanford Law School for 22 years before being appointed dean here at Notre Dame in 2019. He is the 11th dean in the history of the law school. And I think his expertise makes him especially well suited to be our interlocutor for the conversation today with Dame Keegan. So please join me in welcoming the Lady Chief Justice of Northern Ireland, Dame Siobhan Keegan, and Dean Marcus Cole.
Thank you. Thank you so much, Father Bob, and thank you all for being here. This is a tremendous honor for me, Lady Chief Justice, to have this conversation with you. And so I'm delighted to welcome you here to Notre Dame. I think first, as we get started, a lot of our students, alumni, and faculty would love to hear a little bit about your journey, your story of where you went to school growing up in Northern Ireland, your life as a barrister, your practice in family law, and then rising to the High Court and to your current position. So can you tell us a little bit about?
Sure. Firstly, thanks very much for the introduction and the invitation. It's really nice to see faces that I've met over the last 2 days. Thanks for coming out on a Friday evening, which is on a beautiful evening, on the game weekend as well. I'm very excited about the game weekend. So in relation to me and where I come from, I was born in a place called Newry in County Down. I think Grania is here from the Institute, who's also from Newry. It's possibly why I'm here, Grania, so thank you for that. So Newry is situated in the northern part of Ireland. It's about 13 miles from the border with the Republic of Ireland. And my parents had a family grocery store, which was quite an important part of what was a town of Newry at the time when I was growing up. I always tell the story that, my parents put me and my brother out to work very early and didn't pay us, and they would be taken to task nowadays. But the flip side of that was it was a fantastic educational grounding for us to have to, meet customers, work in the shop from an early age. And the shop I've described was not just a place of commerce, it was a social centre for people. So that's where I grew up, and as you can imagine, law was not on my agenda whenever I was thinking about what I would do. I went to school in Newry, St Clair's Primary School, and then the Sacred Heart Grammar School, which was all girls. It still is all girls. It's one of probably only a handful of schools that are all girls in Northern Ireland, but we have a very strong education system which really encourages you to think big without too much pressure. It's a light touch framework, I think, to think, you can apply for whatever course you are capable of and want to do. And I was in one of those brackets where I was good at art subjects, so history, geography, English. And we filled out forms. I don't know if the younger people here do this in America. You filled out forms. What would your personality type translate into as a career? I think I liked animals at the time. I liked horses, so I think I got zoologist. I definitely didn't get lawyer. I think I got air hostess as well at one stage because I said I like working with people. But anyway, the careers teacher said, I think you should try law. And I argued with him. I said, no, I actually want to be a teacher because my aunt was a teacher in Newry at the time. And that's what I aspired to be, a teacher. So this is how it went. I went to the teacher training college, St Mary's Teacher Training College in Belfast for an interview. And I thought I was doing really well at this interview. I thought, all right, I've got this. I'm gonna get in. They're actually going to tell me now. It's so brilliant. And at the end of the interview, the man said to me, do you know what? We will let you in, but I don't think you should be a teacher. What else have you applied for? And I said law. So there you are. I went interestingly, in my year to Queen's 1989, with 4 other students from the Sacred Hearts. There were 5 of us, which was quite a number to go to the law school in that year. There were about 100 in the class. just to tell all the students here the way it works in the UK, you do law as an undergrad. So I went direct as an 18-year-old into a law degree for 4 years. I'm not sure that model is actually the greatest model, to be honest. I think it's quite hard to pick up the language of law at that stage, and I quite like your undergrad model here, and then you go to law school. But anyway, I did the 4 years of law, and then I had to make a choice. Did I want to practice in law, or did I want to do something else with law? But I always wanted to be a barrister. So a barrister is effectively a trial lawyer. I was the lawyer who wears the wig and the gown, and I appeared in court every day, hearing case or representing people in cases. And I was a junior barrister for 12 years, and then I became a senior barrister at a very young age. I became what was a Queen's Counsel then, or is a King's Counsel now, to really run the bigger cases and be a more senior person on the legal, in the legal sphere. And you asked me, Dane Cole, about my subject matter and the work I did. Mm-hmm. So when I started, I had what's called a master. So it's somebody who trains you, a more senior barrister. And he practiced in civil law. And I actually remember very clearly the one thing I said, what's the advice here? Will I do civil law? By civil law, that was largely personal injury cases for people that he did. And he said, okay, my advice to you is don't do family law. So, of course, I did family law. Why did I do that? People ask me this. I think it was the opportunity was there. There was a lot of work at the time I qualified in 1994 in family law because the law had just changed. The Children Act came in England and Wales in 1989 and in 1995 in Northern Ireland. And a lot of the older barristers who were very, very good didn't want to relearn their trade. So I stepped into that, and it meant that I could practice in the higher courts from a very early age. And it was definitely something that I think catapulted me into thinking about further career progression. And I tend to do all these things early in my career because I think intuitively I'm not afraid to just apply and see what happens. So I decided after my 9 years as a Queen's Counsel to apply to be a judge. And we apply in Northern Ireland, as in the United Kingdom, through an independent body to be a judge. So you step up that way. And I've been a judge for 10 years this year, for the last 4 years as Chief Justice. So, whilst I told you my subject matter was family law, I don't do an awful lot of it now. I now am the Chief Judge in criminal and civil law, public law across Northern Ireland, and I sit in London sometimes in the UK Supreme Court as well. So family law is where I came from. It's my heart. It actually taught me, I think, all the skills that set me up to do this work. Because I did a lot of not just private work, but publicly funded work for people who had very difficult issues to get sorted out. So I met a range of people, and that's something that I'm glad I did because in my role now, I'm obviously adjudicating from a position of, well, I used to be down there in the front row, looking up at the judge, trying to persuade the judge as to what's right and what's wrong. So, to be honest, the trajectory has sort of gone very well so far. I hope it's okay going forward. But by that I mean I haven't really stopped. And I was thinking today when I was walking around your campus, your fantastic campus, how I wish I had actually taken a bit of time out when I was younger to maybe go to a university in America or, closer to home. And I wonder, will I ever do that? That is a slight regret. because having that perspective and being, out of your own jurisdiction it's a really rich thing. But maybe I will. Maybe I've got the buzz of Notre Dame now, and maybe I will. Maybe I will come back
more often.
Yeah.
My wife, Angie, who's a school teacher, will be delighted to know that the moral of the story is that if you don't make it as a teacher, you can become a lawyer. For an American audience, I think it would be helpful to explain your role in the court system, and not just your role, but also the relationship of your court to the other UK courts, including the relatively new UK Supreme Court that was recently created. Can you explain a little bit about your position as Lady Chief Justice, as well as your relationship to the courts under you, as well as the UK Supreme Court?
So the jurisdiction of Northern Ireland is relatively young. As a separate jurisdiction, we were formed in 1921. And the courts had to adapt to this new jurisdiction, applying UK law. So our system is one that has to serve roughly a population that's now hitting about 2 million people through courts that are based at the highest level in Belfast, where I live and work. So that's where the Court of Appeal is. So that's the highest court in Northern Ireland. And there's me as a Chief Justice, 3 Lord Justices of Appeal, 11 High Court judges, and we do all the biggest cases. And most of the cases stop at the Court of Appeal with me. So that's all our big criminal cases, all our big civil cases, our public law cases, our family cases. It's really the last port of call. That is save for a point of law, which can, on its own on application, if the Supreme Court accepts it, be heard by the Supreme Court in London. So there is an onward appeal. But the Supreme Court will hear in London about 80 cases a year. And it used to be 2% came from Northern Ireland. It's now about 5%. That's probably because even though we are a small jurisdiction, we generate quite a lot of law that goes to the higher levels. A lot of that is human rights-based law, social policy issues, and they do have a point of law that goes up. So one of my predecessors, who was Lord Chief Justice and a Supreme Court judge, always said we punched above our weight because we're the smallest of the UK jurisdictions, but you'll find our cases have resonance across the piece and are really important. So Scotland is the next jurisdiction, and the system there is really different. They also have an appeal to the Supreme Court. Our system is aligned with the system in England and Wales. So if you came to observe a court with me and went to London, it would be largely the same. So we operate under the same system, although obviously it's a much bigger jurisdiction. So I told you about the Court of Appeal and the High Court. They're what's called the Court of Judicature, so they're the senior court. Under that, there's county courts. Probably you would designate them as circuit courts, and they're round in the local communities. And then there's below that magistrates' courts, which are summary. So they're dealing with the speeding, minor offences. So I'm in charge of about 80 full-time judiciary, but there's a big cadre of other types of law and judiciary that I have to look out for. Tribunal work, so that's employment law. Say a dispute if you're sacked at work, there's lots of judges do that. Social security benefits, lots of judges do that. I think some of us were talking about that today. It's a minefield, actually. It's a difficult enough work. And we've lots of part-time judges, so you can be a part-time judge. So I manage all of that as part of my role. But ultimately, my job and to be honest, the favourite part of my day is when I sit in court in the Court of Appeal. And I sit as a 3, so I'll have 2 judges with me. When I'm hearing crime, I wear red robes. When I'm hearing civil law, I wear purple robes. And I wear a wig when I'm hearing criminal law, not civil law. So that accords broadly with how judges sit in the United Kingdom. And Dean Cole, you mentioned the UK Supreme Court is a relatively new Supreme Court within the UK system. And so it's 2009. And the President came to Northern Ireland, to Belfast, last November to celebrate the 15 years of the Supreme Court. Prior to having a Supreme Court, the highest court on the point of law was the House of Lords. So it was actually in Westminster in the Parliament. And I appeared as an advocate in the House of Lords, which was, I mean, it was a great experience, but quite archaic in a way, with lots of tradition about how you appeared and where you appeared in a committee room. And I remember it was a family law case I went on. I was the first family law case to go to the House of Lords in about 50 years. It was about adoption and whether or not a mother and father should lose their parental rights. And I was for the Health Trust in that case, and I thought we had a good case. But when I went in, it was very hard to read the court. People probably say that about me now, mind you, but Lady Hale, who you may or may not have heard of, was there, and I was a little bit worried about Lady Hale, in the sense of Lady Hale knew everything about family law, and I was thinking, I don't know how this is going to go. But of more resonance for me is my memory that they sat in the committee room, which was it was a beautiful room, very well furnished, but there was a massive painting over the table where the justices sit of some figure being literally slayed, historically slayed. And I was thinking, I hope this isn't indicative of how my argument is going to go. But when Lady Hale started, I was thinking, maybe this is. So I appeared in the House of Lords, and I'm really glad I did. After I became a silk, I got one more opportunity, but that was in the Supreme Court, so I appeared there. Again, in a family law case.
So for our non-lawyers, becoming a silk means you become Queen's Counsel or King's Counsel.
That's when I became
now
Queen's Counsel. Now King's Counsel. So the case I appeared in the Supreme Court was a child abduction case. So again, it was my area and I enjoyed it. And since then, I've appeared, since I've been Chief Justice, I think 5 times in the UK Supreme Court, and I've adjudicated on a couple of cases of real importance, including a case about the Troubles in Northern Ireland and how far you can stretch back applying the Human Rights Act to an event that happened, say, between the 70s and up to date. And that case was quite interesting because it was all about the European law on the point, which was European law in relation to disappearances in the Balkans. So it wasn't related to Northern Ireland, but Europe had said the temporal limit of the Human Rights Act is 10 years. So that meant that there couldn't be a further investigation. And the Supreme Court took its own route and expanded that a little to 12 years. But you can imagine that was a very important case that I wrote a judgment with another justice on. And I've appeared in some other cases, including a family case.
So can I ask something about your office? So does typically the office of the Lord Chief Justice, in your case, the Lady Chief Justice, does that automatically place you on the Privy Council of the UK and the Supreme Court?
Yeah. So once you become either actually a Court of Appeal judge or the Lady or Lord Chief Justice, you become a Privy Councillor. So I am a Privy Councillor. The Privy Council is a fairly ancient body that traditionally advised the monarch in England. It's now made up of about 800 members, so it's a bit different. But it means that you can sit on the Judicial Committee of the Privy Council, which deals with cases from some countries that still have the Privy Council as their highest, or still have the Privy Council or the Supreme Court as their highest court. So there are a lot of cases that come from countries such as Trinidad, Mauritius, different countries throughout the Commonwealth that maintain the Privy Council as their final court. Funny enough, I haven't sat on the Privy Council, I've sat in the Supreme Court, and that's in my position as a Chief Justice. It's not, so that's only a preserve of a Chief Justice to be asked to sit there from Northern Ireland.
So you happen to be visiting Notre Dame at a time when this campus is literally crawling with apex court justices. We had Justice Barrett from the U.S. Supreme Court here last week, and we had Justice Kavanaugh here this whole week teaching at Notre Dame Law School. So you're the third in a week.
Wow.
And you're actually, I'm honored to say, the second Irish Chief Justice that I've interviewed this year, because I had the privilege of having this very conversation with Chief Justice Donal O'Donnell of the Republic of Ireland just a few months ago. And he's an interesting character because he also was born in Northern Ireland and qualified for the bar there, and is dual qualified. And this leads me to a question about the two systems. And you said that Northern Ireland became a separate jurisdiction in 1921. And I'm curious about the divergence in law. How different is the law of Ireland from the law of Northern Ireland?
Yeah. How long have you got? So funny, over lunch today, some professors in the law faculty were really putting me through my paces on this similar question. So the law is different is the short answer. The substantive law is different. The Republic of Ireland has a constitution. So without going into great history on that, the constitution grew up after the Irish Republic was established and has been a feature of life in the courts by way of applications touching on the Irish constitution. So Northern Ireland doesn't have a constitution, a written constitution, a codified constitution, however you might describe it, and that's the same with all of the United Kingdom. But we do have a basis for our law at the minute, which derives from the Good Friday Agreement, which set up Northern Ireland as it currently is. And that's found in the Northern Ireland Act, 1998, which is described as a constitutional statute. It sets up the various different structures and guides us as to how various issues should be determined. But that's on a high level. I mean, on a high level, the law is different. If you break it down to looking at the day-to-day law, I'm not sure it is really that different in the sense of we're a sister jurisdiction. Our criminal law systems are similar. The way we deal with criminal law would be similar. The same with civil law. And it's funny, I heard a case a number of years ago where someone was citing an Irish Supreme Court case to me in support of an argument. And whilst it wasn't, directly on point, I was dealing with an argument about human rights. We have the Human Rights Act, which applies in Northern Ireland. The issue of whether something is protected under the Constitution or whether it's protected under the Human Rights Act was very similar. They mirrored each other in all sorts of areas, particularly under the Human Rights Act, there's a right to private and family life. It's in the Irish Constitution as well. So I could never just go to the Republic and practice automatically. You would have to be called there. I think it would be, quite difficult to pick it up in some areas. But in other areas, I think you could actually transfer relatively simply. As I say, criminal law, quite a lot of our lawyers from Northern Ireland now go and practice in Dublin, and not so much the other way. We're also common law jurisdictions. So, what I mean by common law is that we both have a tradition of judges through cases developing the law. So Republic of Ireland and Northern Ireland, UK are similar on that. That's part of our DNA. And so from that point of view, we're on the same plane.
So I want to ask you another question about the relationship with UK law generally. In the United States, the states, most law in the United States is state law. Yeah. And the state Supreme Courts are the final authority on all state law. Nothing can be appealed to the Supreme Court of the United States unless there's a federal question, a constitutional question, or a question of federal law. So all state Supreme Courts are the last stop for most litigants in the United States. How much autonomy does Northern Ireland have over its own law? Is it a similar structure to what I just described?
Yeah. I mean, the lawmaking is a slightly complicated issue, if I deal with that just briefly for a moment. So we have the Westminster Parliament, which will create acts of law. Parliament will look at law that applies across the whole UK. We also have devolution in Northern Ireland, so we have an assembly that will create local laws. Doesn't matter that much then whether or not either species of law is before a court. We have to then interpret the law, apply the law, and we do have autonomy on that. The Supreme Court route on appeal is an extremely limited route on appeal. So to get there after I hear a case on law, someone has to make an application to me for leave in the Court of Appeal. And leave, I've only granted leave once in a case about about Brexit, because I thought it was of constitutional importance. And I think maybe before that there was one other time when leave was granted. So that is rare.
Very limited.
But the Supreme Court you can reapply to them, and they may pick up cases if they think there is a point of general public importance. So again, that's a really high bar. And out of all of the cases we do every year, there might be 3 or 4 that go to London. So that's out of thousands of cases. So that's why, as an apex court, we are very much the final port of call for most litigation in our jurisdiction.
Let's talk about one particular law, the Northern Ireland Troubles Reconciliation and Legacy Act of 2023. So it's my understanding that act affords conditional immunity to soldiers and others who were involved in crimes during the Troubles, and that particular law faced oppositions from victims and from the government of the Republic of Ireland, leading to a legal challenge in the European Court of Human Rights. And the High Court ruled that part of the act violated human rights laws. Can you please explain for our audience the circumstances surrounding its passage and the current status of the law?
Yeah. So, the statute was made law in 2023. It then was subject to legal challenge before the High Court, which said that the conditional immunity provisions conflicted with the Human Rights Act. So there were other issues in that case which came to my court on appeal, in the Court of Appeal, and various other points were made about incompatibility, including the lower court's finding, which was upheld. That case has been appealed to the Supreme Court and is going to be heard in October. So I'm not going to say anything more about it. But there isn't an actual case in the European Court. What has happened is the Republic of Ireland has applied to bring an interstate application against the UK. So that's pending. But also, it's quite an interesting question today that you asked me, because today the British and Irish government have just announced a new framework for the Troubles, which will see a repeal of that act if it can go through Parliament in various different respects. I mean, all of you will understand, I think, you're interested in Irish affairs, that we have had a troubled past. But we're in a very good place now. We've had peace for a long period of time, 27 years since the Good Friday Agreement. But we still have issues to deal with in our past. And people want to know what happened to their loved ones from a very long time ago. And we're not alone. You know, there are other countries dealing with their past. And it's not easy. And it's very hard to get everybody to agree. In fact, I would suggest it's almost impossible. But what is a strength, I think, and something, you know, we shouldn't take for granted, is that people are trying to find solutions. And also the courts are a place where people can come, and we will do our best, sometimes dealing with cases that are back to the 1970s, to find answers. But again, that's not easy. And I know that because I've heard some of these cases myself. So that's the long answer. The short answer is watch the space, in a sense. The Act is an act of Parliament, so it remains in force until repealed. But there are proposals to repeal it significantly. In tandem, there are legal cases about it, which still have to be finished at the highest level.
I want to ask you another question about the Troubles. So there are still prosecutions taking place of crimes that occurred during the Troubles, including a case involving an ex-British soldier, Soldier F, for killings on Bloody Sunday. And I'm not going to ask you to comment on that or other specific cases, but I'm just curious as to what extent cases from the Troubles occupy the court system now, and when might we see some resolution to those?
Yeah, there are few prosecutions. That is one case that's ongoing at the minute, actually, but there are very few, because you can imagine the difficulties with evidence after such a period of time. So that's in the criminal sphere, but there are lots of civil cases. So there are lots of claims for compensation, essentially, against government through, you know, the different arms of government, the Ministry of Defence being sued for what happened, police. So there's about 700 odd civil cases, I think, in the system. And then there are inquests. And I mean, it's a curious thing with inquests, because there were inquests at the time of these deaths, but they didn't really answer the questions that people needed to have answered. So the Attorney General in Northern Ireland can refer cases back for another inquest, and that's what's happened. And in 2016, my predecessor said, look, we need to deal with all of these and set up a 5-year plan. And I think at that time there were about 54 inquests that needed to be heard. And we did deal with quite a few of them. There was a big gap in getting funding to get them heard, but they started in 2019. And there's still about 25 odd inquests to be heard. So there's civil cases and inquests. But you know, there's a bigger piece here. There's a bigger piece which is general information retrieval and truth recovery type work that's complementary to the legal system, but really important, that I think people are grappling with the best way to do that. And that's where you need a range of people. You need to get victims on board, you need to get the right people to essentially remember and try and lead to true reconciliation if you can. This is generational as well, I should say. And It's just a part of our DNA. But I think we're getting to the point now where we really have to think about people, unfortunately, passing away. And I mean that on in terms of people who were part of the conflict, either as military personnel or victims passing away or getting old. So we're at a stage where we need to get through this. And as I've said, the courts play a role and have done. But the policy end of things and the politics are not for me. We'll simply apply whatever law is there to be applied to these cases for the people who come to courts who need something, and people in authority to at least have a look at their cases.
So I just have a couple more questions before we open it up for questions from the audience. But this forum is about women in leadership, and I'm curious about the status of women in the legal profession in Northern Ireland and how it might compare to other jurisdictions.
Yeah, I'd be quite interested to know whether we're the same as you with women in the legal profession. The number of students graduating in Northern Ireland translates into a majority of women graduating. Wasn't the same in my day when I graduated. There were many more men. So that should translate into women getting into the higher positions. So the partners in the offices, the KCs, the judges, but I'm afraid it doesn't. And therein lies the problem. And I've thought about this, and I've talked a lot about this throughout in different jurisdictions. There's an attrition, obviously, with women having families. It kicks in at about 7 years post-qualification. And that is a problem because I don't believe that there is enough support for women returning to the workplace. We've got better at it, but there needs to be definite incentives to come back. What used to happen, I think, was, you went off to have kids and it became a wasteland for your work. So forget about the financial side, which is another big issue about childcare and how much it costs. You lost your practice. So, I mean, that's a problem. And I've thought about that, and I've spoken to the bar quite a bit and the Law Society about helping young women to come back because, it is a fact of life. I think that women will have the bulk of the responsibility. That's not. I'm not criticising men who I think are a lot better now, but I do think women are sort of stuck with a lot of it, and it's really unfortunate. I've seen a lot of women having to drop out, especially with a second child and trying to juggle. But what I'll say is I've realised that's not it. That's not the only thing. Because there are structures to get help with childcare, you can get back in. And then I see, well, what happens? Do the women progress? Not in the way that they should. And I do think there are systemic issues. And I wonder, I'm sure this transcends law, actually. I don't think it's just law. Law is very patriarchal. The hierarchies are there. They've been embedded for years. It's quite hard to rock them. I was looking just before I was coming here at our stats. The 21% of the judiciary are female. That's the fee paid. That's the big roles. When you get to the lower roles, it's much higher. But that's not enough. If you go back to what I talked about, if you've got this critical mass of more women in the profession, why are they not getting up? So you've got to really be vocal about this. There is an element of you cannot be what you cannot see. And that's why I hope my appointment will lead to further women coming into senior positions. There's a female Lady Chief Justice in England and Wales as well, and I think that will help. I should say it's not just gender as well, it's ethnic background. In Northern Ireland, that might not be such an issue given the nature of our demographic, but social background is a big issue, And we have tried to set up as many scholarships as we can for people coming in who may not have the resources. But again, I think it's a bit more than just resources. I think it's about making everybody welcome in a place where people might not know the language or the traditions or the culture or how to interact. The legal profession needs to represent the community. And I would be very, very sad if we didn't keep it varied and have people who are good academically all getting a chance from whatever background. I don't think it's right to have it as an elitist place or a place for one section of the community. So I'm trying on that, and I mean we're making small strides, but for me I'm impatient for change on this. I told you I became a judge in 2015, and I was one of 2 women in that year to be called as a High Court judge in 90 years, and there haven't been any since to the High Court. So things need to change in that sphere, and people need to be, I think, facilitated to know that they will belong in the profession and be able to reach the heights. So that's why I do talk about this, because I think it's important that in my position I can say, well, look, I got there. I didn't have any legal connections. This is a thing in Northern Ireland, the way we describe it. It's probably the same the world over, but I told you where my family made their living. So I didn't have any legal connections. I didn't know anybody. I just worked hard at school. I was good academically. And I suppose I wasn't afraid to give it a go. And I'd like to see everybody getting the same option to get there, because you can get through. One question I'm asked is, well, did you have any barriers yourself? Was it an environment where there was sexism and you felt uncomfortable? And to be honest, I can't say that I did, but I think that was because I worked so hard. I've told you about my career trajectory. I kept my head down and I didn't look up for breath a lot of the time. But that hasn't been the experience of everyone I know, and some of my female colleagues just didn't feel that they got the opportunities they should have. But even 10 years ago, we wouldn't have had the conversation, because I think the conversation was seen as a little bit difficult and not something you wanted to push. But now we can have the conversation, and we should have the conversation. So.
I think we should open it up for questions from the audience. So I think there's a microphone somewhere here. And Ariel has a microphone. Any questions? If there aren't any, here are questions here.
No difficult questions, please.
First, thank you so much for coming to talk to us today. And then also, when you started learning about the legal systems of other countries, when you're traveling to London, being here, did that change your perspective about anything regarding Irish law?
Yeah, I mean, as part of my role, I do get to go to London and Dublin a lot. I'd be there nearly every month. And then I go further afield, like here and others. And I think comparative law is really, really good. How you do things will inform me. Let me give you an example. On this trip, I learnt a lot about your JD programme in relation to mediation. Thought it was brilliant to hear about that from the students. I heard about problem-solving courts, which we have in an embryonic way in Northern Ireland, but we can observe what you do, albeit you're on a bigger scale, and take it back and bring it into our world. And I'm really going back to the past here, but I came to America. America is a very important place for me because I came on a J1 visa when I was 21, so 1992, to Ocean City in Maryland. I don't know if any of you know Ocean City in Maryland. It's a bit of a beach place. And I worked in a fudge shop, and I met an American guy who was a lawyer at the time. And why that? I mean, it was formative just being there when you're young, but I was so impressed with how he studied and the way you studied and the methodology of study. And the US constitutional law. So I'm really keen on looking at that across the piece as I go through my career. But on this trip, I'm taking back your mediation program and your problem-solving court. So that's one trip, and I usually take something back from every trip I go on. Really, it's really good.
Thank you.
Another question up here.
Hi, so I was wondering, what have you found most difficult about working on laws related to the Troubles? And also, have you experienced any political intimidation or your colleagues at all?
Yeah. So in answer to the second question, no, I haven't experienced any political influence or intimidation. The big strength is the judges are independent, and that we don't cross over into politics in our courts. In relation to the Troubles cases, the difficulty is, they're historic cases, firstly. Evidence is hard to find. And they're also really hard. They're emotional cases for the people. And I think the most difficult aspect of it is you cannot decide the case just on the request of the people before you, even though you might want to. You have to go on the law. And that can be difficult because sometimes you're disappointing people. There are two sides to this debate, as you can imagine. But you as a lawyer apply the law. That's it. And you have to take a step back. So that can be difficult. That's not just Troubles cases, actually. It's lots of different cases, and you just have to realise what your role is in your judicial oath. And we take a judicial oath when we are called as judges to do right to all manner of men without fear or favour, affection or ill will, according to the laws and usages of this realm. And that's what you just remember, and you do that. That's a good question.
Thank you.
Thanks,
Hi,
Dame
Grania.
Keegan. It's so lovely to have you here. I can't wait to compare notes about the Sacred Heart. So
I think Grania was the head girl of Sacred Heart, as I was, so that's another connection. That we have.
I wanted to ask you your comment about your regret that you hadn't lived abroad for a substantial period of time. I feel like maybe you're being a bit harsh on yourself, because as I remember it, the girls who I was at school with who went to Queen's went into the law, it seemed like there was a specific track there. There was a lot of momentum there that was hard to break. It would be hard to go and study abroad once you were on that path at the time. Maybe I'm wrong. And it was part of the reason I didn't choose to study law at Queen's, actually, because it was one thing I thought about. I'm wondering, do you think that has changed for a younger generation? Because we've had Irish students from the north and the south here doing masters in the law school, and do you think that mobility within the career trajectory of a lawyer in Northern Ireland or in the south has changed at all?
That's a great question, Grania, because I think it has. I think whenever I was going through, you did your degree, then you did your professional degree to be a barrister, then you were a barrister, then you were a judge, as I am, and then, that was it. It would have been hard to go off that for a year even, or 2 years to do a master's. I did apply. I had a place. I was going to Edinburgh to do a master's in international law. I also applied at one stage to William and Mary. I think it was in Virginia. Yeah, that was when I had the American man. Sorry, my husband's here now. He does actually know about this, but well, I think he does. But I think you're right. I thought to myself, I'm going to lose out here. My contemporaries, there were the 4 others who were in law, my class. It was very hard to get into the professional school, so that was to get my professional barrister qualification, because there were only 20 places. So once I got that, I wasn't going to drop it. But now is different, because now I think it is easier to come back in. And actually, I think people who have had time out have a bit more on their CV and a bit more maturity and do very well. So this year, I have 2 JAs. And I brought in judicial assistants just 3 years ago. We didn't have them in Northern Ireland. And I'm noticing that they have been away, they've done their masters, they've come back. They're not afraid to take a gap, and they're coming back in. I think also that you need to distinguish yourself more by going places, doing different things. Not just law as well, I should say, sport, charity, church, whatever you're interested in. But just to tell you again, this is a very eerie, set of coincidences. My JA this year, whenever she started 2 weeks ago, Ellen Kearney, she was here. She did her LLM in Notre Dame. So she gave me all the recommendations. Ellen, yeah. So I think it is different now. And she's quite content to wait. She'll do the year with me, and then she'll do very well, as will, I think, the JAs I had in the other years. So it is different, but I do regret it, Gráinne, and I'm thinking ahead, because I started on this pathway young with going to senior levels. Maybe when I'm retiring, not waiting to 75. Maybe if Brian would come with me as well, we could go and take a master's in America. I think we'd really enjoy that, Brian. Right. So there you are. That's Brian told. Yeah. This one over there.
As a child of parents from Northern Ireland and the Republic, Ireland was long, many people emigrated. But now with the changing times and with refugee seekers and asylum seekers, what impact are you seeing in your caseload, and how is the law evolving to change with the changing populations?
Yeah, that's a really great question as well. Firstly, you've touched on the Irish diaspora, and it's something that I spoke about recently in London, that I think in times of old we exported some of our best. I think it's changed that people are staying and going to university or coming back, north and south, that's great. But the makeup of the community is very different now, north and south, with different communities coming for asylum or to basically settle for different reasons. Post exit from the EU, there was a free movement of peoples from Europe that came. So there's that constituency. And then there's the people who have been persecuted elsewhere who've come. So our caseload has changed to adapt to the different cultures that we have in our society. There are practical things that we've had to adapt in the courts to make sure people understand the courts, obviously. I think that goes beyond language, though. I think it's an understanding of law and culture, and in some cases what we do is try and bring in experts to help people from different countries to understand just what's happening and how we're explaining things. And there are some very difficult cases in the immigration area in relation to the Human Rights Act and family life that we've had to deal with. Not at such a sharp end or critical end as London has had to deal with. And why they're so difficult are, this is part of a big political piece that we're drawn into sometimes as courts, but we ultimately just have to apply the law, and that's a really important thing for anybody who is entitled to have a case heard. But I think we will see a different complexion of cases as well, given the changing world. So you've tapped into something that is true in terms of the work that we do. Yeah.
Hi, I have a question. You mentioned a few times about the distinction between the courts and politics, and others make the law, you apply the law. And I'm curious as to your thoughts about, in our current situation here in the U.S., in recent years and under this current administration, in terms of references to judges as who appointed them, an Obama-appointed judge, or things like that. And I'm wondering if what effect you think that kind of the comments from politicians about judges, what impact that has, if any, on the people's view of the fairness of a court.
Yeah.
Like when they go in, are they going to get a fair hearing
Yeah.
if this judge is appointed by a certain politician? I'm curious about that and its impact on the rule of law.
Yeah. I'm not really qualified to talk about America, and I don't think it would be good of me to do that. But what I can say is within the UK, we are obviously proponents of the rule of law, and any attack on, judicial independence affects that. I think it affects public confidence and the integrity of the system. So we have to protect that I actually think by education. So, certainly in my own jurisdiction, I'm going to have a project this year to bring in I don't want to just talk to lawyers who know this language. I want to talk to the bigger society about how important it is to have independent judiciary in our jurisdiction. There are a couple of things that we've thought about in relation to this as well. Understanding what judges do is one of them. So I do a lot of educative pieces with schools. I go to the Northern Ireland Assembly and talk to the Justice Committee, who are the politicians, about what I do. I interact with my colleagues in the UK on that as well. I'm trying to bring in broadcasting of some of our sentencing in courts so that people understand a bit better, because you can have various different attacks on the rule of law, but all of them are chipping away at something that's precious. So, we have it in our own way, and people like me, I think, have to just try and keep the educative element of this high on the agenda. Okay, but the rule of law is really important.
Chief Justice Keegan, since you had the good fortune to practice and experience the House of Lords firsthand and sat on the Supreme Court, which court system do you prefer and why?
You're going to get me in trouble. Look, I think the Supreme Court was a very good step in the UK because it took the highest court out of Parliament. So it's like the lady asked me the question about the interplay there. It took the court, it is literally over, it's over from Westminster in a beautiful building, but it's separate. And I think that was a good step, and I think it's really important. And it's a court that's made up of representatives from each part of the UK. And it's also, if you look at the work that the UK Supreme Court does, it is really good on outreach, and it's really good on explaining what it does. All of the cases are broadcast, so you can watch live a Supreme Court hearing. And that's important, and openness and transparency is a big strength we have, I think. The arguments in cases are now going to be more open to people to see, so you can follow the argument. Now, that might be easier in a human rights case than a tax case. But there are maybe some of you like tax, I don't know. But, people can really see how it operates. So I think it was a good system. I think it was a good move to do that. Yeah.
Could we take one more question?
See, thank you for being here, Lady Chief Justice. I actually had the privilege of being in your courtroom a few times this past summer. I was working for Niall Murphy at KRW Law.
Yeah.
So I have two questions on the troubles. I'm not sure what extent you can answer them.
Okay.
But with talks of replacing the Legacy Act with a Legacy Commission,
Yep.
To what extent do you think the Secretary of State should drop the Dillon appeal? And then secondly, if it is replaced with a commission, how do you think that affects the facts in Sean Brown in terms of is it an exceptional case to stand apart?
Oh, you're pushing the boundaries. You know that anyway. So the Dillon appeal is the appeal from. Is KRW in that? Are they in that appeal?
With another person.
Okay. So that's the appeal from the Troubles, from the Legacy Act that's gone to the Supreme Court. It's an appeal from my decision, so I'm going to say nothing on that one. On the second case, that's a difficult case as well, and that may be appealed. So I don't think I can say too much on it. But I'm glad you've been in our courts, so you've seen how we operate. I hope you took away a positive experience, a positive view of it. It is a court I want to showcase where people can make their arguments and they'll get a fair hearing. They may not like what I decide or others decide, but you can have your hearing. We'll give you time. We'll give you a judgment within a reasonable time, and we'll serve everybody who comes in front of us. But it's an interesting time for all of that litigation, so you'll follow it, I'm sure, from here, or if you're back in Belfast, you're welcome.
Well, we are so grateful that you're here visiting us, and we have a small gift for you that I'd like to. It's very small.
Okay.
It's a difficult box to open, but
Right, okay.
I should help you with this. Here, if you take that.
Yep. All right, thank you.
I might need to help you with that as well.
Probably easier to. Oh, right, okay. Very nice. Well.
So it's designed to hold Irish whiskey.
For Irish whiskey, right? Okay. Thank you very much. Thank you.
Thank you so much.
Very much.